This legal shorthand 100 words per minute. Ready? Start. Similar view is reiterated by Supreme Court of Rana Girders Limited (Supra) while dealing with liability of auction purchaser to pay outstanding dues of central excise or of erstwhile owners and observed in paragraph number 21 as under. Para. A harmonious reading of the judgments in Macson and Seacombe would tend us to conclude that it is only in those cases where the buyer had purchased the entire unit, that is the entire business itself, that he would be responsible to discharge the liability of central excise as well. Otherwise, the subsequent purchaser cannot be fastened with the liability relating to the dues of the government unless there is a specific provision in the statute, claiming first charge for the purchaser. As far as Central Excise Act is concerned, there was no such specific provision as noticed in Seacombe as well. Proviso to section 11 is now added by way of amendment in the Act only with effect from 10/9/2004. Therefore, we are achieving our discussion regarding this proviso as that is not applicable in so far as present case is concerned. Accordingly, we thus hold that in so far as legal position is concerned, capital UPFC being a secured creditor had priority over the excise dues. We further hold that since the appellant had not purchased the entire unit as a business, as per the statutory framework, he was not liable for discharging the dues of the excise department. Para. The aforesaid exposition of law would make it clear that if auction purchaser has purchased entire business as ongoing concern, it would be responsible to discharge liability of erstwhile owner. However, purchaser in case of assets of dormant business, auction purchaser is not liable to discharge liability arising out of business of erstwhile owner. In present case, careful reading of stipulation in a tender notice and sale certificate would show that auction purchaser has agreed to discharge all liabilities, dues of authorities and departments in respect of secured assets and, if payable in law, attachable to secured assets, sale proceeds. It is therefore important to find out whether dues claimed by petitioner were attachable to secured assets. Para. Admittedly, petitioner credit society had advanced amount to respondent number 1, which has been defaulted. Therefore, petitioner approached cooperative court seeking award for recovery of amount. In absence of charge of aforesaid dues on assets of respondent number 1, respondent number 2, auction purchaser cannot assume such liability. The executing court has rightly observed that Petitioner was not diligent while process of auction was undertaken by Maharashtra State Cooperative Bank under provisions of Sarfasai Act and now trying to shift liability on auction purchaser. Stop.